Yes, you will. You will. Just serve them. The hearing as 11.
One is Tuesday. And you asked for remand in industrial area or where?
Yes, in the industrial area, prison.
My lady, today is the first day.
So I'm looking at the time and wondering, when it comes to procedures, by the time we process that, it will be another time of the day.
I'll be the first one not to do it, but sometimes we are forced to sit. So on the 11th is when the plea will be taken. 11th is Friday. That will be in the morning, so you'll be free after that. Yeah. All right. I also want the DR to extract this order so that it is served on the OC industrial area.
To take you, not the investigating officer.
Mr.
Yes.
When he was taken to
before the hearing and serve it on the defense, and then in the meantime she will remain in custody until we come back tomorrow.
Please remember I've said written submissions, so it will be easier for the judge to quickly clear the islands.
To just go over it so that we don't come and find we can't continue. I'm aware of your matter. I'm coming to it. Yes, yes. Did you have any other matter? Is that tenable in that hospital?
That one is appealable. I don't think any hospital will restrict the doctor to see his
I was proposing, yeah.
The matters for mental assessment to be done. And after the mental assessment is done, we thereafter can take plea as the time given in any other matter by this court.
You are saying something?
Yes.
And if they are not able to treat him, they will refer him. I confirm that he has been treated. He received medical attention.
Hivi tusichekwe kama
15th in the afternoon is because of that long matter she's handling. Mine I'll be able to do it in the morning.
If they want to be enjoined in this matter, they then need to have gotten directions whether they're being enjoined.
All right? And in my view, she's the right person to review that order. So the directions I'm giving you in this application is you are going to serve all the parties. That is the prosecution, the interested party, the family, and Mr. Mood for the defense. Okay? So I'll give you the judge is very busy, but when I consulted on the matter of the date, because I knew that is the direction this matter is headed, she gave the direction that you'll be before her on 15th of this month, in the afternoon, because she's handling that long matter, that is yet to end. And between now and that time, you serve all the parties as I've directed. Yes, they are also going to put in their responses. Okay, you serve your responses, and you prepare written submissions. So when you appear before Justice Lesit, it will be highlighting. Then she will be able to give to hear you and give orders as may be necessary. Yes.
Directions, you said 15th before Justice Lesit?
Yes.
Is 15th the day we are coming here also for the application?
to enjoin somebody, an interested party, in the trial. I believe that's in the trial. Number two, the review of the ganging order.
Really the purpose of doing is to canvass the issue of that is solely the purpose why.
Yes, it's all right. But are you saying you're not interested in the main trial, just the order?
That order only.
This order is the one you...
Came to our attention, my lady. We wrote and we informed the court that we have written. And knowing what has happened, my lady, we are therefore not in a position to expose them. But it's only information. And my lady, if you give us time, we'll be able to demonstrate when it happened and why we are in this position. Because we even have an OB report as to that. And then the court and everybody else will be able to understand why these witnesses' identity at this particular time would be jeopardized, or it would be jeopardizing the prosecution's case and their identity. But we're just asking for those few days to be able to see what we can do in terms of their protection. Then we can reveal their statements as to be annexed in our affidavit. Because he who alleges must prove.
Counsel, I'm really belaboring. I'm just
wondering what to do. But one way or the other, things have to move. And my direction is going to be very simple, that we've worked on this file for long, okay? If these objections had not been made when they were made on 26th, I think we'd be now in a different stage altogether. I'm going to give you time, Counsel, but it is tomorrow. We are arguing this matter, we are listening to this matter tomorrow, and I want to set time at 11, if that is available for everybody. You have between now and then to do your papers, if any. If not, let's come back tomorrow at 11 and have the matter heard.
Can we come on Monday?
No, I think I'm saying tomorrow, Counsel. You are two of you there, you are going to work, and I think I had somebody, the police officer there, an investigating officer, just sit on that file and let's have that matter heard tomorrow, this matter heard tomorrow. Okay?
A similar offense, which we still haven't seen, has no bearing in the matters before us. I don't wish to say more because I don't hold that brief. And I haven't seen who has been charged, what for, and in what circumstances.
Miss, are you
Directions on this because he has no right to reply. And I was answering the court questions on this.
Okay, I was just picking up the point she had made. If it's in the interest of justice that these witnesses, their statements are retracted, then again we will be supporting that. And we will also be saying that whatever the prosecution will be doing in regard to protecting the identity of the witnesses and their protection as persons as a whole, we are fully in support. We'll be ready to respond at the time when the opposing of bail. If the state will be opposing or they will not oppose, on our side we will be opposing.
In the interest of justice, we are praying that we'll be given the 5 days to be able to liaise with the witness protection as to whether, or get a confirmation as to whether our request is acceptable. Again, the lady, they work under NOAA's directions. They're the ones to make a finding whether there is any probability of the witness being protected and what form of protection. And that is our prayer. 5 days to allow us be able to prepare our affidavit in response. Noting, my lady, that as we
listen to, perhaps you can just have a look at it.
Yes.
Then the issues come up. Before the
Yes. Yes,
I am on board.
yes.
My lady, there was an application that was filed on the first day of October 2019.
The matter I'm handling.
Yes.
I seek your indulgence, 15 minutes break, we come back to the rest of the course list. I know I kept some matters.
If I may add, milady, the condition of our client is acute diabetes mellitus.
Mr. Kiprono, I've pronounced myself.
Yes.
All right, so I propose to take the plea on that Friday, 11th. The 10th is a holiday. So we come back on 11th.
I don't know what exactly happens. If they are, there's no problem with that. For us, definitely we have no objection. Because it is important.
I respond to.
Oh, sorry, maybe there's one issue, sorry.
Sure.
I've just been reminded. And I believe most of them are taken to Kenyatta National Hospital. But my lady, we are not experts in that field. We acknowledge that. And I pray that we let the experts make that decision. But I believe as part of the procedure, they are first seen by the clinical officers or the medics at the prison screen. And I pray that we allow them to make that decision.
My lady, treatment. And his blood pressure also has risen, and it has taken care of medication and day-to-day advice by his personal doctor. We are ready to avail, or rather we are ready to avail ourselves for plea on the date that the court will appoint, and give this tomorrow. Thank you. From the 10th of September. During which period an order of custodial, or rather a custodial order was issued by Honorable Stella Tambo on the 16th of September for a period of 14 days, which period has expired today. The reason why we wish to state that also is that our client has been under a medical condition of diabetes, and for that period the blood sugar has really affected him. It has gone to levels that are very critical, that might render his health, or rather that might render his stay at the cells dangerous for his health. We are asking, Your Honor, that as our client continues to stay under his custody, he be taken to see his doctor, Dr. Njenga, personal doctor at Aga Khan Hospital, on a daily basis. I say so because on Friday our client had a terrible condition. Has been under the custody of police for the last 24 days. During which period?
Because there are some preliminaries we need to do, that is mental assessment. I note that you have defense counsels who have recorded in court. Yes. They cannot argue argue the application for bail. That one I've not heard. So why are we talking about it?
For those 5 days, my
Mhm,
lady,
mhm.
so that when we are replying or when we are responding to or giving evidence in terms of the complaining reasons,
Mhm.
it is important for us to annex the statements, their statements. My lady, if you look at the bail bond policy guidelines, we must prove 1 or 3 issues, or we must prove 1 or 3 things. And one of them would be whether there was interference, whether there's a possibility of interference, whether the relationship between the accused and those people, whether if she would be released, there would be that. In the bail and bond policy guidelines, there are a number of things we would need to prove to the court. And for us to be able to prove, because he who alleges must prove, for us to be able to prove that, we must attach, for instance, even that the offense was serious, we have to attach the post-mortem. There are things we need. So we're just asking to be able to give. Because if we give them as they are.
I'm not recording this, I just want to understand.
Where you are coming from. When you look at the court order that brought this matter before me, before this court, everything was supposed to be done on 26th.
Yes.
That is the plea taking,
Yes.
the bail application,
Yes.
as per the order, which is I'm reading here. So, how has the prosecutor used that time?
My lady, that is what
Because when you look at it, they filed their papers. Mr. Mbeta filed his papers in respect to the bail application. How have you used your time?
Yes, my lady, as even we stated as we came last time before you,
Mm.
in view of what information that we got.
And she's stating them from the bar. To the best of my knowledge, the body of the deceased was recovered 1 day after the charge was preferred. Let me put it this way, the recovery that we are aware of, maybe there was another recovery. The one we are aware of was on the 13th of September 2019, 1 day after. That is 20 days ago. That is more than plenty of time to have compiled any evidence that they have. Indeed, Top Cohen had a right to life. And those who took it away must be held to account. But for now, I'd like to assure my colleague, the prosecutor, it is not Sarah Wairimu Cohen who is responsible for that matter. So it can't be advanced as a reason. This case has a very bad precedent on the time aspect of it. In fact, from her own words, the case has developed and things have happened. It shows that an accused person was held in order to enable them to conduct their investigations, rather than for them to finish their investigations.
If I can, with all due respect to my learned friend, when I was uttering those words, I was responding to his submission saying that this Mr. Top Cohen's body had not been found, and therefore this matter has progressed.
The investigating officer, the one standing here, said to the chief magistrate, we need to place certain witnesses under the witness protection program. And thereafter, that thread has continued. I have said it more than once before. In other words, they arrested her 37 days ago, assuming that there was some evidence upon which to arrest her. They did tell the court that there had been some witnesses who had recanted a statement. They had more than 37 days to place that witness under witness protection. They have not used it.
that time very usefully at all. The Act allows the process of witness protection to take place immediately. In other words, if a witness is vulnerable or needs protection, they can be taken into protective custody the same day. They have squandered the time, 37 days. In addition, they charged Sarah Wairimu Cohen 21 days ago. 21 days ago. And when they came to court, they broke the law because the charge sheet did not have copies of the evidence which the prosecution intends to adduce at the trial. The charge sheet says, and I quote, "Copies of the evidence which the prosecution intends to adduce at your trial are attached herewith." I emphasize the last two words. Attached herewith. There should have been a bundle, there should have been a statement, there should have been a report or a stand. We have been asking for that until today. What do we hear today as a ground for asking for a few more days? We want to redact some witness statements. Redact some witness statements. Leadership, as I understand that statement, means they'll provide us a statement and they'll black out or white out some portions. That could have been done 21 days ago. Should have been done before she was charged. But at this stage, we have no objection to them withholding a statement if it exists, even one if it exists, that is called evidence against our client, until it is redacted. Meaning, they should have provided the statements that do not require redaction, and the ones that they think require some work, with leave of the court, or even later we can bring them in. The law permits them to do that. But that is not a reason to defer the application that we have made. Bail is a constitutional right, even for the offense when one is charged with the offense of murder. The record will show that it is entirely the fault of the prosecution for not dealing with the plea earlier and for not allowing the application for bail to be considered. I do want to say this, they have also not filed a replying affidavit in opposition to our application. Mr. Ombete has. He's looking at me. Mr. Ombete, on behalf of his, are there two clients? Yes, two clients has. The prosecution has not filed an application in opposition. To the extent that on the 26th, isn't it? On the 26th of September, we, on behalf of the accused, filed a supplementary affidavit. It's dated the same day, sworn by the accused. And there has still been no replying affidavit. So I am opposed to a further adjournment. Consider this matter. In fact, it is, I would say it is unopposed and it can be dealt with in short order in the course of the day. So I beg that the court overrules and denies the application for an adjournment.
My lady in brief.
Might join hands with them to speak first. Those who represent the siblings of the deceased. Then I can respond once and for all to all of them.
So is any, Mr. Newton, do you have any address?
The statements as they are will be jeopardizing the
Section 203 as well as Section 204 of the Penal Code, Cap 63 years of Kenya. The particulars are on the night of 19th and 20th July 2019 within Nairobi County in the Republic of Kenya, joined with others not before this court, the murdered Tom Chichu Cohen.
First, confirm whether you understood what she said.
Yes, I Seems not clear.
Presented that you are not guilty. You will sit.
Just confirming whether we were given a copy, because it usually, because it was pursuant to a court order, so they usually file in the court.
Yes, and we'll be grateful if and thereafter we'll be permitted to apply for her bail and release on bail. That is the order of business. We've already filed our application for bail in anticipation.
Through your affidavit, Mr. Mugo, and your submissions in court, and the objection by Mr. Mbeta, and support on that objection by Ms. Maniki, within my knowledge and the knowledge of every one of you, I want to go to the issues. I've read all that you've filed before the court. I've also read the two authorities who've cited, and also the responses from Ms. Maniki and Mr. Mbeta. Of course, with a lot of objections as to not filing the affidavit by both of them. So in determining this matter, I understand the singular issue for determination before me as whether Mr. Mugo's appointment as a public prosecutor still stands, and therefore by virtue of that appointment, he is not in a position to represent the accused person in this case as a defense counsel. I have read the affidavit by Mr. Mugo. I have read the submissions by all the parties in this matter, and I've understood the same. I note that Ms. Mwaniki did not file an affidavit as directed by the court. For our submissions were made from the bar, a fact that led to objections by Mr. Mugo. Mr. Obeta too spoke from the bar, although I note that the order of this court did not direct him to file an affidavit. It was Ms. Mwaniki who sought time to confirm whether the Gazette notice appointing Mr. Mugo as a public prosecutor had been revoked, and this explains the silence of this court's order in directing Mr. Mbeta to file an affidavit. From the outset, it is clear to me that it is not in dispute that Mr. Mugo was appointed as a public prosecutor for 2 years with effect from 15th of January this year. This is a fact that is admitted by all the parties. There is also a copy of special issue of Gazette Notice number 350 dated 16th of January this year as proof that to this fact. Mr. Obeta and Ms. Mwaniki contend that Mr. Murgo is still a public prosecutor, and as such he cannot represent the accused person as defense counsel, as this leads to a conflict of interest. Mr. Murgo, on the other hand, contends that he resigned as a public prosecutor effective 7th of March this year, and that he is no longer a public prosecutor as argued. He argues that he is properly before this court as defense counsel of the accused in this matter. This dispute leads to the issue before me, whether Mr. Murgo, while still a public prosecutor as contended by Mr. Obeta and Ms. Mwaniki, can still purport to act as defense counsel for the accused. The two learned counsel buttressed their contentions on the lack of evidence of revocation of that appointment of Mr. Murgo as a public prosecutor. It is also clear to me that there is no dispute that Mr. Murgo tendered a letter of resignation as a public prosecutor. The letter of resignation was accepted and receipt of the same acknowledged. This is not denied by the prosecutor, Ms. Mwaniki or Mr. Obeta. The only condition on the issue being that the letter of resignation cannot override a gazette notice revoking an appointment or this appointment in issue. In the words of Mr. Obeta, the letter of resignation is not conclusive proof that Mr. Murgo is no longer a public prosecutor. I note further that it is not denied that Mr. Murgo continues to attend courts in criminal matters as a defense counsel. There are no submissions from Ms. Mwaniki or Mr. Obeta countering the submissions by Mr. Murgo that he has been attending court as defense counsel in other criminal matters and also in this particular case. It is noteworthy that there is no evidence presented to this court showing any objection raised against Mr. Murgo's standing as defense counsel in this matter, in this court or in other courts from the time he first appeared as defense counsel up to 26th of September this year when this objection was raised. It was not denied that Mr. Murgo is in his capacity as defense counsel in various criminal matters as directed with the ODPP in general and Ms. Mwaniki in particular. The fact that Mr. Murgo has been representing clients charged with criminal matters as defense counsel is known to the ODPP. This was after the letter of resignation. It is also clear to me that there is no dispute that Mr. Murgo, upon resigning as a public prosecutor, returned all the documents relating to the particular case he was assigned, and that was acknowledged. Read the letter dated 14th of March this year, marked PKM 10. This fact has not been denied either by Ms. Mwaniki or Mr. Obeta. Mr. Murgo claimed that the objection raised in this case was calculated to delay the plea taking in this matter, and as such it contravenes accused right to fair trial as provided under Article 50 of the Constitution of Kenya. He also claimed that by arguing that he is still a public prosecutor and denying him the chance to represent clients against the DPP is in violation of his rights under Article 30 of the Constitution. I've looked at those articles. The Article 30 is about, reads as follows. Number 1, a person shall not be held in slavery or servitude. And number 2, a person shall not be required to perform forced labor. And I think the argument by Mr. Murgo is that he is being forced to do exactly that. Article 50 of the Constitution of Kenya guarantees an accused person the right to a fair trial. This right includes the right to be presumed innocent until the contrary is proved, a right to be informed of the charge with sufficient detail to answer to it, a right to have the trial begin and conclude without unreasonable delay, and also a right to choose and be represented by an advocate and to be informed of this right promptly. I need to point out that the rights under Article 30 and 50 of the Constitution of Kenya cannot be limited. This is by dint of Article 25 of the Constitution of Kenya. I have read and understood the authorities cited by Mr. Murgo. This is the Okia Omtata case. And in this, and another one, that is Eric Cheruyot and others. The Okia Omtata case concerns 3 commissioners of the Independent Electoral and Boundaries Commission, who on 16th of April 2018 address a press conference publicly announcing their resignation from the IBC with immediate effect. The 3 commissioners also sent notices of resignation to the President as required under Section 7A(1)(b) of the IBC Act. The 3 commissioners returned to office to resume duties despite their resignation giving rise to that particular petition, and they held the view that although they had publicly announced their resignation and notified the President as required by the law, they were still commissioners because it was up to the President to actualize their resignation by publicizing vacancies in the offices of 3 commissioners in a Gazette notice. In determining that matter, the court, that is Mwita J, observed as follows, and I quote, "It is plain from the reading of the constitutional text that there is no provision for commissioners' resignation. The Constitution speaks of removal from office, which means that the action to remove a commissioner is third-party driven as opposed to self-desire to leave. That cannot, however, mean that a commissioner who desires to leave cannot resign because the Constitution does not allow it. In my respectable view, a commissioner, just like any other person, has a constitutional right to leave the commission if he wishes, and no one can stop him. To leave employment is a right to make a choice, and therefore a constitutional right that cannot be limited, as it is not legally possible to force one to keep a job he or she does not wish to." And the court continued, and as the Supreme Court observed in John R. Mwang and 2 others versus IBC and 2 others, that no one could be forced to participate in an election he has lost interest in the same vein, there is no way a commissioner can be forced to remain in office if there is no longer such motivation simply because there is no constitutional provision for resigning from office. The court in the same matter, Okiya Omutata, continued to state as follows, and I quote again, "Furthermore, from the reading of the statute, the President does not have discretion whether or not to accept the resignation. He is only notified by the commissioner of his resignation, and the President's mandate is to initiate the rest of the process by declaring a vacancy, which leads to the process of recruitment. In that respect, therefore, it is my finding, and I so hold, that resignation of a commissioner is immediate upon notifying the President in writing of that resignation, and publication of the vacancy in the Gazette is a foremost step and has no bearing on the actual act of resigning." I end the quote. In the same vein, the court in the Eric Cheruiyot case, also cited by Mr. Mugo, was of the view that resignation is a unilateral act that does not require acceptance. I've given this matter, the issue before me, much thought and consideration. I find that I'm persuaded by the authorities cited and also the provision of the Constitution on the rights I've cited above. Although in the Okiya Omutata case, the issue before the court was based on a statute providing for the manner in which removal from office should be undertaken, I find the same principle in that case relevant and applicable in this case. The reasoning of the courts in both cases is of persuasive value to this court. My view is that no person should be forced to remain in office, once they have chosen to resign from that office. I agree with Mr. Mudgo that his resignation, as contained in the letter dated 7th of March 2019, was immediate upon submitting to the appointing authority the letter of resignation of that date, which letter was received and that receipt acknowledged. It is my finding, and I so hold, that the appointing authority did not have discretion in the matter. Publication of a Gazette notice revoking that appointment, that is appointment of Mr. Murgo as public prosecutor, in my considered view, is a formal step by the appointing authority, and that step has no bearing on the actual act of resignation of Mr. Murgo. As submitted by Mr. Murgo, which are submissions I agree with, the publication in the Kenya Gazette is meant to notify the public, and not to change the fact that he has resigned as a public prosecutor. Consequently, the objection raised by Mr. Mbeta and supported by Ms. Mwaniki is hereby rejected. I find that Mr. Murgo is properly before this court as a defense counsel for the accused person. I find that his representation of the accused person in this case does not raise a conflict of interest on his part, since his resignation as public prosecutor is effective from the time the letter of resignation dated 7th of March 2019 was received and acknowledged by the OTPP. I make orders accordingly.
Most of that,
In the meantime, and my orders here read as follows, that the officer in charge of the remand prison at industrial area shall ensure that the accused is escorted to Mathare Mental Hospital. The earliest date I can come up with is 8th. 8th is Tuesday next week for mental assessment. The same officer in charge of that remand prison shall also ensure that the accused is escorted to Kenyatta National Hospital for medical checkup and treatment, and a report of that treatment filed in this court on or before the date I'll take the plea, which I'll give you just now.
Malady will request them that if he is taken to Kenyatta National Hospital, then his doctor will be able to observe him and attend him at that hospital. Because we are saying matters of health are very important. And if someone has...
My lady, when we came before the court, we did explain why we had not attached the statements to the information. Consider protecting our key witnesses, my lady, their role is one where no one can direct, and therefore we are praying that if our request will be acceptable, they will be able to redact the statements and my lady, it is important for us to have those statements redacted for us to be able to prove all
here
In respect to what is the application about?
Firstly, the applicant intends to be enjoined in this case for the purpose, my lady, of seeking a review.
Because what I have here is an application and a certificate of
Indeed.
the court stamp reads second.
Yes, but it's dated the 1st. It was received on the 2nd, but the application itself is dated the 1st day of October.
Yes, I'll come to it. Can I just handle that?
Most obliged. Thank you.
So, all right.
Signed by a doctor and Kiamu. Perhaps we can share with the court to have a benefit of their house. We are also inclined to pray that, I don't know whether that is tenable, that he be admitted to special diet owing to his...
Are we in this country together?
That's why I began by saying I do not know whether it's tenable or not.
Yeah, but my concern is to have him attended to.
Yes.
Medically, so allow me to make my orders and change what I've said.
And most of that, the state as an hospital where the accused person can be taken, which is Kenyatta Hospital. We object to the same vehemently because the accused person as a doctor at Aga Khan, who has, even before the date of his arrest, who had been monitoring his health condition, and therefore he knows his medical history. When the accused person was in custody, DCA purported to take him to a clinic somewhere. His blood they tested the levels, but did nothing. He was not placed on medication. They did nothing. As my senior has indicated to this court, it took us to write a letter to DCI, Mr. Kinoti, and the DPP. It is only then when the letter reached the DCI and the DPP when DCI woke from slumber and rushed him to the hospital. We do not want the same to recur again. So we kindly request the court that the accused be taken to his personal doctor. It's a right. It's a right, and I do not see any difficulty in that. We are not telling the court that he be admitted. We only requested that he be taken to his personal doctor. The other issue is on the mental assessment. I believe that is an exercise that can be done within a day. So we pray that they can undertake it today. Then we come tomorrow for plea taking. Mr. Otieno is now become familiar. Is in court and can take him to Madari Hospital today, because looking at the clock is now around 12 noon, and the accused can be attended to today, and then we come back tomorrow for plea taking.
Maybe just a clarification with the investigating in terms of even relationship, well, because there is a provision that we need to show whether there was a relationship in terms of either employer-employee, those kind of things. We will require their statements because we cannot be able to be talking from the bar. We will require their statements to be able to prove those particular small ingredients that are required to prove compelling reasons. And my lady, there will even be an OB abstract. There will be so many things to show. Interference, threats, those kind of things, and that is contained in their statements. Was found, and that's why we need the said witnesses protected. And that is why we are asking for time to have their evidence or their identities protected, for us to be able to adequately demonstrate interference or why we have compelling reasons in this matter. My lady, this matter has developed, advanced. There is a co-accused before you in another matter. And therefore I'm praying, my lady, in the interest of justice. Top Cohen also lost his right to life, a right given to him under the Constitution, that this court balances both rights, both the rights of the accused and the rights of Mr. Top Cohen, which was taken away. Therefore, we are praying for those days, my lady, to be able to convince this court by the compelling reasons, and that is all.
Saying that they would like a little more time to do some work. They're not, they would like her remanded, correct? They are saying that we can argue bail another thing. But let me take it this way. We filed the application for the release on bail on the 16th of September. (17 days ago). At that time, it was anticipated that we would be, upon the directions of Her Ladyship Justice Lesit, we would actually be arguing the application for bail. The court ordered us to serve the application, and we duly served it on the same day. I see here 17th, on 16th. We served the other parties on the 17th. It is an application where there is an affidavit sworn by the accused on the 16th, on the same day, 16th of September 2019. And so it does not lie in the mouth of the prosecution to say now they require more time. When reasonable time is requested, we will be the first to accommodate our colleagues. Again, having been prosecutors, we sometimes understand time is something that they need. But in this case, it has been 37 days. 37 days since the accused was arrested. I don't want to give the chronology, but as the time before the Kiambu Chief Magistrate Court, they were given 14 days, thereabouts. Came to court, the High Court, we applied for revision, all this kept going. And in total, today, as we sit here, they have had 37 days. At the very first instance, shortly after she was arrested, I think it was the 29th, 28th, when we went before the Chief Magistrate, 29th,